Tuesday, opening statements began in a California federal courtroom in a trial that outlets are calling one that could reshape some of the world's most popular apps. That framing suggests we don't yet know whether Meta will be held responsible for harming kids. But 5 months earlier, a jury in New Mexico already answered a nearly identical question and ruled against Meta, finding the company violated consumer protection law, hid what it knew about child exploitation and mental health harms, and engaged in what jurors called unconscionable trade practices. Penalties from that case have now climbed past $940 million combined. So if a jury already decided this, why is Oakland being treated as the moment that determines Meta's fate? That gap matters because Meta also faces a separate ongoing trial in Tennessee, a wave of state lawsuits, and a new wrongful death suit from the families of 4 teenagers, whose deaths their families allege followed years of escalating platform-driven harm. If the pattern is already set, that raises a real question about what any single verdict actually changes for Meta's roughly 2 billion young users worldwide and for how every other social platform designs its products. So this isn't really, will a jury find Meta harmed kids? That's arguably already been tested once. The real question is narrower and more specific. Does one state's jury verdict against a trillion-dollar company actually change how the product works, or just how much it costs to keep running it the same way? To answer that, we need to look at what these lawsuits are legally targeting, why that target was chosen deliberately, and what's different about California's case that keeps this fight going even after New Mexico's verdict. So look at what actually made this possible. In November 2025, a Los Angeles judge, Carolyn Kuhl, made a decision that reshaped this entire fight. She ruled that a design features theory, targeting autoplay, infinite scroll, algorithmic recommendations, and notifications could go to a jury, while claims about actual content stayed blocked by Section 230. That ruling is the real mechanism behind every case since, including Oakland. States aren't arguing Meta should have removed harmful posts. They're arguing Meta engineered the mechanics that kept kids scrolling regardless of what was on the screen. A distinction that let plaintiffs route around a legal shield that's protected tech companies for 3 decades. Here's the number that complicates a simple Meta is losing everywhere narrative. That first bellwether trial in Los Angeles ended not with a knockout, but with $6 million total, $3 million compensatory, $3 million punitive. Against a company Meta's size, that's closer to a rounding error than a deterrent. New Mexico's penalties landed far heavier, over $940 million combined, but that case ran under state consumer protection law, not the personal injury framework LA used. Different legal theories are producing wildly different price tags for what courts agree is the same underlying conduct. That's the problem with treating each verdict as decisive. These aren't isolated trials. They're bellwethers inside a consolidated, multi-district litigation covering roughly 1,600 pending cases against Meta, Google, TikTok, and Snap. Their real function isn't justice in any single case. It's calibration, testing how juries respond so both sides know what settling the other 1,600 should cost. Which means Oakland was never really about whether Meta harmed kids. Courts have already treated that as established. Oakland is about setting the price, and whether states enforcing consumer law can extract something LA's smaller jury award couldn't. Not just damages, but a reason for Meta to actually change the product.